we're watching, and it doesn't look like there's going to be any major discussions here after the jury has gone home. My guess is that the judge wants to get everybody out of there pretty quickly, because this is a courtroom that usually runs 9 a.m. to 4 p.m. in testimony, and of course the staff has to be there to set up and take things down, and a lot of times courts are really worried about driving things into the overtime spectrum, and we're just now watching it on our actual live feed, because what you're seeing is a few seconds behind. The defendant sitting there listening in, but it looks like they're going to bring him out of the courtroom, we're hearing. So that's where things stand right now. It's been an interesting day of competing doctors on the stand. I counted 4 of them, and they all seem to have something else to say. So, Julie, yes, we've been trying to chart this out, and again, the jury is going to have to try to sort through the big question here, and that is as follows. Once the defendant raises the defense of mental disease or defect, the jury has to decide basically whether he can understand the law, and then whether he can conform his behavior to meet with what the law expects of him.
Right.
I'm paraphrasing it, which I know I should never do, but just for sake of discussion, that's basically what it says. And the doctors are back and forth all over the place on whether or not he can or can't understand the law. Most seem to think that he can, okay? But then of those who thought that he could understand the law, many of them were saying, well, he can't conform to it. At least that's what 2 of them said. And then the other 2 said, no, he can understand it and conform to the law. I would hate to sit on this jury, because it's ultimately a trial about this defendant's sanity and not whether or not he did it, because we know he did it.
Well, that is always what
I mean, it's always
an
what the
insanity defense case is.
But it's that much harder for the jury. It's easier for the jury to say, well, is this the guy or is it not the guy? Is the DNA accurate or was it planted? I mean, it's easier to get into factual things for a jury rather than to try to get inside somebody's head, especially when every single expert seems to have a different diagnosis.
Well, again, if every single expert has a different diagnosis, then one argues that none of them have, one can't really accept what anyone's saying, because if you assume that every doctor is like educated and knows what they're talking about, and one comes up with a completely different conclusion, then the jury's left to either say he's completely mentally fine and they all have it wrong, or he's mentally ill, but we just can't figure out which way he's mentally ill. I mean, you know, one of the things that I think the prosecutor was trying to do in regards to this witness, amongst many other things, is kind of establish the fact that this was a guy that basically lived a fairly normal life. He had friends, he had relationships, he had people that came over to his house, he was on a swim team, and he had relationships with individuals that kind of, goes against the grain of this, doctor saying that he, he uses, I guess, the word schizoid, and it's such a mental disease or defect that he couldn't conform with the laws. He also goes into the fact, which I thought was interesting, was that the defendant blames his father for the death of his dog, but he was able to conform with the law by not killing his father or not hurting his father, who he believed had hurt him, and arguably to the same extent that these women or this woman had. And so what he's trying to say to the jury is, if he can conform then of course he could have conformed in this scenario as well. He just chose not to. Just a little thing, but I understand where he's going, because he has to go there in order to win this jury over.
Well, is there any basis to the presumption then, which I assume would be the counter argument, to say, well, maybe the dad didn't occupy as high of a place in his life, and that's why he didn't try to kill the dad in this dad-dog scenario.
Right. I don't know if it's that he didn't place it. I think the argument would be that the delusion didn't exist with his father. The delusion or the craziness existed with this specific woman and his viewpoints of this specific woman. I mean, look, I mean, this doctor, while he spent a lot of time with the defendant, I don't know that he necessarily explored everything. One of the things they talked about is that he viewed the woman, I forget the word, like remember we talked about like superhuman, or like that she was superpowers or whatever, but it wasn't explained to the doctor to mean, is this just a guy who's infatuated with a girl, and so he, as guys do, they might find the woman to be super, like fantastic, or is it really that he views her in a delusional way?
Well, there's back and forth opinions on that as well. One of the doctors testified earlier in the case that this is not any sort of romantic infatuation, although it sounds an awful lot like it.
It sounds like it is, and then it sounds like I don't look. I mean, I don't know, and the fact that I don't know maybe does go
Play
towards
into
the
the
defense
defense.
because I'm a little confused myself. Because look, when the prosecution first started out, it almost sounds like they were saying that in fact there was some type of sexual assault. It seems to have changed or varied now to not being a sexual assault, but instead that he was just incredibly obsessed with not only her but kind of both the wives, and was delusional in regard. I admit that I am a little confused. I don't really know what actually happened.
You're not alone. So look, I mean, it boils down to this thing up in Alaska, which is kind of sort of relevant, but in the grand scheme of things, it's not horrendously relevant other than to get into what's going on in his head. And he's saying ultimately that he thought that this woman was, some extra special friend or obsession or romantic interest or whatever you want to call it, because the opinions are all over the place on that spectrum. But that the accusation is that when Anna was out of town, Lisa invited him over and, in his mind, seduced him.
Right, or mentally seduced him, whichever.
Mentally raped him was the phrase that was being kicked around in court, and I'm just like, well, I didn't realize there was such a thing as mental rape, but apparently there was. In his head, okay? Again, this is inside the head of the defendant. And a lot of people are just looking at it saying, is that really what went on? Was he making it up inside his head? Was he seeing things that weren't there? Did she just think he was friendly? There's some insinuation, and I expect the defense is going to bring this out, is to try to get into a little bit of blame the victim here and say she toyed with him knowing that he might have been interested in her. And
I think that's an incredibly foolish way to go.
Yeah, but I've seen it happen time and time again.
I understand this is not the case to go down that road. It just isn't. I mean, especially if you're
even if the victim had done so sort of innocently and said, well, this guy kind of likes me, so maybe I can invite him over, and then say all this other stuff, and kind of she took it as either funny or flirtatious or something.
But if you start doing that as a defense attorney, then you're feeding into the prosecution's position that he's just a guy who's been jilted and is hurt, and so therefore he's made a rational, albeit crazy, decision. But that he knew that he was doing something wrong and just was angry and went and killed this girl. So I would be very careful as a defense attorney to start going down the road that in some way she provoked it, because if you accept the argument that she did something wrong, then you start to go, well, then he knew, as the defendant, that he should not be going after her, and he did.
Well, no, I think I agree with you in part, and I disagree with you in part, because the defense, if it has the guts to go there, and I'm not necessarily saying I would go there if it were me, but the defense could turn around and say, what was taken by her to be some sort of playful or joking thing,
Sure.
he, because of this mental disease or defect, perceived in a totally different way.
Sure, but then you're not blaming her as much as how I perceived you initially started. Then it's more just a woman just like engaging with a man that she knows and talking to him or flirting with him, whatever it is.
And maybe she even knew that he was had the hots for her, or was somehow interested in her, or had some. I'm trying to come up with a word for it, but some sort of attachment that was beyond what most normal friends would have for one another.
Right, and
that she may have sort of, oh, well, this guy seemed, even if it was completely innocent, maybe.
But to me, I guess the defense's best position is to kind of, in a sense, leave her out of it and kind of just go with who he is and kind of the way his mindset. Because the truth is, it doesn't matter at the end of the day. I mean, I guess it does matter if he didn't even know who this woman was and just made up the fact that he knew who she was and created this whole story about how she hurt him and he'd never met her, we'd all be sitting here going, he must be completely crazy.
Well, yeah, and we know those cases, and
right?
we know where they were.
Right, he must have a mental disease.
Celebrity assassination cases,
exactly.
That kind of stuff, they get locked away.
And this is, do they get locked away in a hospital or do they get locked away in a jail? Because some of them are so delusional they get locked away. We see this all the time with individuals that are stalking celebrities where they don't go to jail, they go to a mental hospital because they're not well and they have no idea. The argument is they don't really understand right from wrong. And so this one's kind of weird because it's in the middle. He does know them. He does know his victim. However, the question becomes, is he delusional about what the relationship was between him and the victim? And you start to think maybe he was, especially because you also have the friend who had spoken about how he seemed kind of obsessed with a relationship that I don't even know that he really had, you know? And it just, again, when you start to think about this case and kind of the logic of when you think of an average, I hate to say an average murder, someone kills someone, they take a gun, they kill them. The lengths of which he went to not only kill this woman, but to put it on tape and to guard against police.
Write the manifesto, to take X-lax so that if the police shot and killed him, they wouldn't have to clean up any spontaneous bowel movement.
Right.
I mean, it's just like...
But the question becomes, is that someone who's crazy? Or is it someone who's mentally ill but still kind of is thinking out and knows the difference between right or wrong and is trying to cover his steps?
You draw the critical distinction here, and that is that mental illness does not necessarily make for, or I should say a diagnosis or a mental illness does not necessarily make for a defense of this nature.
People kill all the time. Many people who kill have a mental illness. That doesn't make them not responsible for the death they caused.
The question is whether or not he could understand the law and conform to it. And I think that I said that the critical part of this case was not going to be all the shocking detail, but it was going to be what the expert or experts have to say. I didn't realize we were going to have 4 of them.
Sure.
For all I know, there may be 5 or 6 other ones that are going to come down the tube here over the next couple of days. So now we've got these competing experts, and at this point, from a legal perspective, I don't know which one of them to believe and which one of them to not believe.
Right.
Hey, note to yourself, Julie, if you don't like an expert, just throw so many of them in front of the jury.
I've never seen that.
That you can't make any sense. And you know, they're all making ultimate legal conclusions, which is a side issue I wanted to get into later. But at the end of the day, I think this case now is just going to, it's going to all hinge on the closing arguments and how everything gets characterized.
Right. Also keep in mind, at least with this doctor is basing a lot of his decision on what the defendant told him, not necessarily on the outside evidence that's telling him whether or not what the defendant is telling him is accurate. So, you know, I'm sure they looked into whether he was malingering. I think I didn't hear any malingering unless there was something that I didn't hear some of the doctors. But so, you know, when you rely only on what the defendant is telling you, there is some you have to be suspect of what he's telling you to make sure what he's telling you is accurate when you're making a determination as to his mental
Well, you know,
illness.
it just made me think of something else, and that is that this defendant had attempted to self-diagnose.
Right.
So then you get that element in there before he even goes and talks to all of the 4 who have been on the stand over the last couple of days.
Right.
And then that just adds another element into things. You know, he thinks something's wrong with him, and then he goes and does this.
Right, but I don't know
if he's so good at planning the crime, did he plan the defense when he was planning the crime?
Yeah. By the way, I can't. That's one thing I would be shocked. I can't accept that just because no one in a completely rational state would do the things he did to get the objective he did. To me, it's mind-boggling what he did. You know, setting the fire and, you know, doing it and the X-lax, but doing everything in his power to kind of make sure this went down the way he wanted it to. But I always go back to this with these cases is that, remember, the jury is left with the concern always that or at least that they think sometimes that when they find someone not guilty by reason of mental disease or defect, that somehow that means that that person is going to be out on the street. And sometimes that fear takes over, and sometimes the jury will just disregard kind of the mental issue and make sure this person is secure in jail.
Well, let's talk about that for a second. And this is one of the next areas of research that I'm trying to get into here, and there's so many of them that are novel with this case. One of them is the issue of access to Coast Guard records. It's really hard for prosecutors to get military records and bring them into a civil court, and I'm trying to read up on some of the law review articles about it to figure out why we keep hearing so much talk about them, but we don't have them all in evidence. And if they're going to be brought up by the defense, then why not get them? But then the defendant, in at least one of the vehicles for getting the records, would have to waive access to them, and the defendant refuses to. So the defense is having experts
Well, no,
testify as to what the defendant said about what's in the records, but the defendant won't let anybody get the records and put them into evidence.
You can't. But that's a problem because you can't have an expert. You're saying the expert's reviewing
is talking to the defendant about the military. So the defendant tells the expert about the military records.
Right.
Then the expert's up on the stand saying, "Well, my understanding of what happened is that he got this, this sort of a it's not even really a discipline record, this so-called page 7. It's more of like an administrative note that's in somebody's permanent record when they're in the Coast Guard.
Right.
Okay, they can be used for positive and negative things. A lot of them have to do with like pay.
Right.
Okay, it's not like a formal discipline proceeding. But he got this thing, they keep talking about it. Well, he told me about this and he told me this happened, he told me about that happened, but we don't have the record in evidence.
Well, usually, I understand the Coast Guard may be more difficult than some, but usually a court can mandate a subpoena and mandate them to be in court. The question becomes, even if the prosecutor were to get what's called a so ordered subpoena and get the documents to the court, it would be for the court at that point to make a determination as to whether or not there's anything relevant for the prosecutor to see. I don't know. I obviously don't know because I don't know the details of what happened prior to this. But certainly I find it troubling.
Well, the state court can subpoena it, but I don't necessarily know if the federal branches of service, and keep in mind Coast Guard,
right.
Coast Guard is Homeland Security, and then the other 4 are under traditional military, but my understanding is that they don't need to respond to it.
I understand, but see, here's the problem then. The defendant should not be permitted to talk about records if the best
evidence is not on the record.
Well, or in a sense, if the argument is that the way to get those records is for the defendant to agree to allow those records to be turned over. And he refuses to, I'm not saying that this is the situation, and he refuses to, then one would argue, then how should he be allowed to, or how should a witness be allowed to testify about that which is being of the records being described without anyone getting to see the records?
Yeah, I'm not sure. I would love to see the motions in limine. Those are the motions that attorneys have to file to try to jockey back and forth about these evidence points prior to trial. I'd love to see what they said, because what I'm seeing in this courtroom is bad evidence lawyering on both sides. I have have offered praise where I think it's due in this case, but I don't see objections. I may have seen 1 or 2 in this entire case, and time after time I see things like, wait a minute, why are we even going there?
Like
First
what,
of all,
though?
why is it relevant? Why is it, why are we going in some of these areas?
Right. I mean, look, I think people object, prosecutors object, and defense attorneys object for various reasons. Sometimes they just object because sometimes people won't object because after a certain pattern of events, if the judge is never going to agree with them, they stop doing it. There's some judges that every time you object, they overrule you, so you realize that you don't want to look bad in front of the jury, so you shut your mouth. On the other hand, when a judge sustains you all the time, then you may tend to do it more because then you have the judge on your side. I don't know, is this a strategy on their part? They don't know the law, or they just think that there's nothing that's coming out that's hurting them. I don't know.
I want to take a quick break out of our spirited discussion here to see if we can play clip 94. This is one of the many experts that's been on the stand. This is one who gave an ultimate opinion right out of the gate. Let's listen in.
Did you eventually form an opinion? Yes.
I did, yes.
And do you have an opinion to a reasonable degree of psychological certainty as to the defendant's criminal responsibility on February the 5th, 2015?
I do.
And what is that opinion?
Adrian Loya on February the 5th in the wee hours of approximately 2 a.m. of 2015 was suffering from what we refer to as a delusional disorder. It is a psychotic major mental illness that was exacerbated by a major depressive disorder. But primarily it is the delusional disorder that deprived him of the substantial capacity to appreciate the wrongfulness of his actions at the time or his ability to conform his conduct to the requirements of the law.
Is there another aspect of your opinion that supports that conclusion?
Well, this culmination of diagnosis that I've just outlined was within the context of an individual that suffered for most of his, certainly his adult life, but even preceding that, there were signs of what we call a schizoid personality disorder. And it's not uncommon. In fact, research has helped us to understand that many individuals with delusional disorder have a pre-existing personality disorder. The most common of the personality disorder is paranoid personality disorder, but the second most common of the delusional disorder antecedents, that is the personality disorder antecedents, is the schizoid personality disorder. This would be the diagnostic understanding of Adrian Loya that leads up to February the 5th of 2015.
Now, you first indicated, I believe you said, Dr. Delusional disorder.
I did, yes.
Now, did you use a particular diagnostic criteria when you came to that conclusion?
I did. I followed the criteria of the Diagnostic and Statistical Manual version. We're in version number 5 now, so it's called for short, the abbreviation is DSM-5.
Do you have those memorized?
Do I have all of the criteria? No, I don't. It's a very voluminous document, but I have a working knowledge of the document.
Well, I'm a ways away from you, doctor. If I were to hold that up to you, could you take a look at this chalk? Is that consistent?
So one thing that's interested me here, Julie, is all of these experts are getting up there and spitting out the buzzwords that are contained in the model jury instructions. And if that happened, I would at least be lodging the objection to say, why is this witness providing an ultimate legal conclusion?
No, and I understand that, and the argument would be is that they're not giving a legal conclusion; they're giving their opinion as to his mental illness. And so, while I understand you'd object, I don't know that the judge would sustain your objection.
Hey, look, then I would just keep objecting to put it on the record.
But see, I mean, and I hear you, but remember, we talk about this judge being kind of strict and a little bit.
Strict.
I'm going to use I'm just going to stay with strict. And so you don't want to anger him either. And so, yeah, I understand that your viewpoint.
Yeah, but when you're objecting, you're not talking to the judge, you're talking to the appeals court.
I understand that, but one objection is enough to make your point. And then what you can do is, out of the presence of the jury, make an additional objection and explain why you're objecting. So I think that's enough, at least, after objecting 1 or 2 times. Again, I think they're giving their legal opinion. I'm sorry, they're giving their opinion, which they're allowed to do. You got me.
You agreed with me. You were trying not to agree with me, and it sounded like you
really,
did.
I don't know what just happened to me. It was like my brain just froze. But they really, to me, they're simply giving their expert opinion. And their expert opinion is that the guy's not responsible. Or he is responsible, depending on which doctor
I'd be making the old objection saying, I don't like these experts trying to invade the province of the jury, because then the jury's got to get this lengthy instruction that really they're the ones that have to decide that issue.
The best thing you do then in situations like that is you make a motion in limine before they testify, and you say, listen, judge, I understand they're allowed to give their opinion. I understand they're experts. But what they're not allowed to do is, say, and use the legal definitions, because they are not, you are the decider, you are the judge who's going to let the jury know what those legal standards are. At that point, the judge usually will sometimes be on your side, because then he may be more aware of it when they do try to draw legal conclusions.
Yeah, that's one issue going on here. We talked about the Coast Guard reports. We talked about the page 7. Some testimony about prior bad acts has come in here as well, things that he has done in the past. A lot of it was little stuff, but I thought that was interesting that came in. But he's making his mental processes of issue here, and that opens the door up to a lot of evidence that normally would not be in a trial.
I agree, and I think it kind of anything becomes fair game, especially and depending on what the bad act is, it can be something that helps him or something that hurts him.
So that's going on. it makes this a very different trial to watch because so much of what's coming into evidence is material that we normally would not see in a run-of-the-mill case.
Sure, and I think it's hard. I think any case is hard for the victim and the victim's family. I think this is especially hard because what ends up happening is I think the victim's family starts to feel like you're losing sight of who the victim is in this case because the focus becomes purely on the defendant and his mental illness and less about the life that was taken.
Yeah, well, this is going to be an interesting trial to continue to watch here. Julie Rendelman, LawNewz trial analyst, who also has 2 other titles that I'm not allowed to say.
No,
that if you need to hear them, you should dial back to other previous editions of the Julie Rendelman, Aaron Keller show here on LawNewz. There's clearly an inside joke between us that she doesn't like me giving her other 2 titles, which happen to be attorney.
I can't believe you're
related.
explaining it, you know.
But for those who haven't seen us go back and forth about this, Julie Rendelman, LawNewz trial analyst,
Thank
you for joining us
Thank
today.
you so much.